I'm a living testimony, as my CV will show. I had the opportunity to go to school. And Mr. Chairman, permit me to say that it's very essential that an employer must always try to encourage the staff, and in this case, not, as I said, not only the judges, but also the auxiliary staff and the registrars. I had the privilege of working with judges. I was in Sekeni High Court when I had the opportunity to go to school. I worked with a judge called Ansetrum. I owe Ansetrum a great of gratitude. May his soul rest in perfect peace. I was my judge, so I was the crack to him. I was very, very committed to my work, and the man took interest in me. I may say that Justice Ansetrum, late Justice Ansetrum, was a prophet. Why do I say this? He taught me that, Bright, go to school, and if you went to school, you were going to be a great lawyer. I didn't take it serious. But when the time came, I saw the wisdom in it, and I applied myself to what he said. So I had the opportunity to go to the university in 1988 to read Diploma in Public Administration. I went back to Sekeni, and then the following year, I had a chance to then go to the law faculty to read law. Went to Makwala to do my professional course, came out, and then went back to the service. Started as a magistrate, and I haven't looked back. So, and I must say, with all due respect, that my work has always spoken for me, and the records are there. It was because...
So, my lord, we don't intend to keep you here for long, so be brief.
So, what I'm saying is that I will say that when we want Ghana judicial service to grow in leaps and bounds, we need to, one, build the capacity of the judges. There's this myth that the law is in the bosom of the judge. But if you, the judge, you do not educate yourself, how would the lawyer come and say that the law is in your bosom? So you need to educate yourself. Two, the infrastructure of the service, when you go to the hinterlands, they are so in some. I started from Sehi also. We were, so we need, and with your approval, please, when our budget comes here, I'm pleading, don't cut our budget, approve for us, so that the Chief Justice will use that to, acquire more, build more courthouses, renewed office accommodation, resident for the judges, because when you work in a serene environment, that even gives you the edge to work hard. I also think that there must be some reforms even with our laws. The law that we are using, they must be overhauled. For example, the Act 30 was passed in 1960, and there's a need. Now we are in 2025. Some of the provisions have achieved its usefulness, so we need to, amend some of them so that there will be speedy recovery, speedy trial of cases, and so forth and so forth. My experience has shown that I will give premium to capacity building, and not only judges, but also the staff, and particularly the registrars. Thank you, Mr.
Any follow-up?
Thank you very much. Yes, I have a follow-up. So you would agree with me, my lord, that that there hasn't been proper, for instance, orientations, proper trainings, proper in-service training for persons like registrars. You agree with me?
To some extent, I will. But to a larger extent, I will. And what it does is that it organizes courses periodically for judges and the registrars. I have even trained some registrars of the Court of Appeal and court clerks. So, and in recent past, some registrars were sent to the UK to undergo some studies. They said rapes or raper, I've forgotten exactly what it is, but all in an effort to build the capacity of the register. So it's not only the judges that these courses are offered to them, but also to the registers as well. But of course, the JTR, that is the Judicial Training Institute, must be resourced so that they can organize more and more courses for the registrars. Thank you.
Thank you very much. Any further question?
Yes, my Lord, can you tell this committee, how often does the JTI organize capacity building workshops, for instance, for registrars? Let's limit it to the High Court.
Well, I will take that to be a fresh question. So, question number 2.
I know for a fact that they do organize this. They do organize courses for the registers, but how often I cannot tell. Thank you.
Is it the case that when registrars are appointed, no form of orientation is given to them before?
To a very large extent, I would say yes. Thank you.
I don't know about your last question.
A follow-up to this one. That was the second question. So I have a follow-up.
You want me to treat it as your third question?
No,
so that you ask a follow-up on
to
this?
the second question. The last one was the second question.
Yes.
Yes, so I have a follow-up to the last question.
That is the training for... Very well.
Yes, now, my Lord, would you advocate that the budget for the judiciary is prepared in such a way that enough funds would be set aside for the training of both the judiciary and staff of the judicial service? Would you advocate that?
Thank you. In fact, that system is already in place. Parliament has given the judiciary part of the revenue that we generate to oversee it. But you see, it's not enough. So, like Oliver Twist, we are saying that more and more resources must be given to the judiciary so that we can work efficiently and effectively. Thank you.
Thank you, my Lord. Now, from the internally generated funds of the judiciary, 30% is retained, while 70% goes to the government. The judiciary is always struggling to meet its demands. Would you advocate the uncapping of the funds so that the entire 100% of funds generated would be left for the judiciary to do business with?
Subject to the fact that that is not capping, you may proceed to answer the question.
Mr. Chair, can you repeat the question for me?
Very well, my Lord. My Lord, what I mean is, funds generated from the judiciary the judiciary keeps just 30% of the said amount for its use. The 70% goes away to the government. What I want to find out from you is, in view of the fact that the judiciary is struggling, do you think that it would be appropriate for some law being passed for the judiciary to retain everything it generates?
Indeed, it will be a good if that was done, but I'm afraid the revenue that we generate is also backed by law. It must go to the consolidated fund, because it is from the consolidated fund that the government, applies to its activities, including institutions of state and the judiciary. So, to say that the judiciary should retain 100%, I will not advocate for that, but I will say that maybe about 50 or 70% must come to the judiciary. Thank you.
I'm very good.
Thank you very much. I will then give the floor to Andy.
Thank you very much. Congratulations, my Lord. Yes, my Lord, I've gone through your CV, and I've also listened to you on the reason appointed a Supreme Court judge.
Thank you.
You have done all that it takes to become a judge, right from through the ranks at the Supreme Court. And I think that I will not worry about whether you are qualified to be a Supreme Court judge or not. You are. And so I have no questions for you, my Lord. As far as I'm concerned, you are fit for the job and you are fit for purpose. Thank you.
Thank you.
Congratulations.
Thank you very much. It's now the turn of Honorable Tampuli. You have the floor.
Thank you very much. My Lord, good morning and welcome.
Thank you. Good morning.
And congratulations, my Lord.
Thank
my
you.
Lord, I heard you talk about the jurisdiction and the workload of courts in Nigeria, Federal Republic of Nigeria. And I want us to do a bit of comparison with ours here.
Okay.
So the Nigerian Constitution 1999 as amended, and in their case they call it sections. Section 2302B of the Nigerian number of courts not exceeding 21, an act of the National Assembly. In Ghana, ours is in Article 1281. The Supreme Court shall consist of not less than 9 other justices of the Supreme Court. End quote. So, in other words, they have a ceiling, but we have a floor. So, at some point during the presidency of President Buhari, they even had 13 justices of the Supreme Court, the Federal Republic of Nigeria. But is this sustainable? And having regard to the fact that Article 128 is not an entrenched provision. The entire Chapter 11 has Article 125, 127, 145, and 146 as the only entrenched provisions. Do you think we should do something about this, especially having regard to the fact also that 230 million people reside in Nigeria and about 32 million in Ghana? We have not less than 9 they have not more than 21. Don't you think by reason of these numbers, ours is a bit on the high side and potentially can even go way higher? Thank you.
Thank you, Mr. Chairman. I will start off by saying that if there should be need for expansion or capping of the Supreme Court, I think that there must be a wide and expansive consultation. Constitutional lawyers, I mean, the academia, even the political parties themselves, so that we will all come to consensus as to what we must do. And if there's a consensus that there should be a cap, then the law has to be amended. I also looked at the law, and that is not an untrained provision of the Constitution. So the amendment, as it were, can be done without much difficulty, except that, as I advocated, there must be a very wide consultation. I brought this report, an annual report of the Judicial Service, and as at June 2023, this report was issued to us last week. 595 cases were pending in the Supreme Court. So when we are talking about capping, we must also take into consideration, as I've said already, the number of cases that are in the Supreme Court pending for attention. Thank you.
Chair.
Any follow-up?
Follow-up question.
The ground rules.
I acknowledge, the ground rules. In view of the expansive jurisdiction of the Supreme Court, chieftaincy, jurisdiction, election, Supreme Court, presidential elections, and so on and so forth. Now, don't you think that there is need for us to stop the jurisdiction somewhere of the jurisdiction of the Supreme Court, especially, you can take, for instance, interlocutory appeals. Rules of Court Committee can, by CI, come up with something. Can you propose some limitation to the jurisdiction of the Supreme Court? Which jurisdiction do you think should be set aside and at the Court of Appeals? And then which one should continue to remain with the Supreme Court? And by the way, at some point, the Supreme Court of Nigeria had over 10,000, pending cases. At some point in 2022, over 10,000 pending cases. I thank you, Mr. Chairman.
Thank you, Mr. Chairman. You see, I will say that first and foremost, the Court of Appeal must be very strong. I mean, being strong means that we need judges who, they are doing their work very well, I must admit, but we must make it stronger than now so that some of the cases may not travel beyond that. But there must also be conscious effort on the part of the legislature and then the Rules of Court Committee to ensure that, and of course we can't do that without, we have to subject the debate very wide so as to see the number of cases that will go to the Supreme Court. Because, permit me to use the UK example. UK, most of the cases end up at the Court of Appeal. The cases that go to the Supreme Court will go there with the leave of the Court of Appeal or the Supreme Court. So you find that they do very little cases, and so the Supreme Court is always, they are not saddled with so many cases. So if that is what we want to replicate in Ghana, then the law itself must be amended so that some of the jurisdictions must be taken away. For example, if I should be given the opportunity to say, to recommend, the prerogative of mercy that is exercised by the president, I think that should remain with the executive. It shouldn't come to the Supreme Court. Because after all, the Supreme Court itself has pronounced that when it comes to matters of advice, the president may take it or may not. Thank you.
My Lord, with the leave of the chairman.
Please, he said the mercy, not writ.
Prerogative of mercy.
Mercy, yes, prerogative of mercy, which is vested in the president. The president may come to the Supreme Court for advice. And once the interpretation placed on the advice is not compulsory or is not binding on the president, he feels that it should rest with the president. Yes, 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 yes. Honorable Bafoewa, you have the floor.
Congratulations, my Lord.
Thank you, Chair.
My Lord, I was happy to hear you say that there is the need to build a strong court of appeal so that a lot of the cases that travel as far as to the Supreme Court will be reduced. My Lord, when you take the law reports of the Republic of Ghana, there's one observation you are likely to make. A significant number of the cases determined by the Supreme Court, by the Court of Appeal, are overturned by the Supreme Court. In recent history, if you even look at the number of judges being appointed from the Court of Appeal to the Supreme Court, it's indicative of how strong our Court of Appeal is presently. But this is the situation. Why are we having that experience? Because currently we say we have a strong Court of Appeal, yet a significant number of cases are being overturned by the Supreme Court.
Thank you, Mr. Chair. In fact, I haven't had the benefit of that research you are talking about. So let me file a caveat. I will not be able to answer directly why that is the case. If I've had benefit of it, maybe I can profess an idea as to why that is the case. Thank you.
Thank you very much. Honorable Alik Blim Akurugu.
Thank you, Mr. Chair. Congratulations, my Lord.
Thank you.
Yes, there has been growing concerns about expanding access by breaking the monopoly of the Ghana School of Law. There are a lot of people who have completed their LLB and are home. Some of us are even planning to go read law, but we get scared about what is happening. What do you make of it, or what can you advise for our students who have been home for many years and haven't been called to the bar? Thank you.
Thank you, Mr. Chair. The number of students that are trying to get to the law school has increased significantly, because now we have universities that are offering LLB courses. In our time, it was only the University of Ghana, and then from there you come to the law school, so the number was few. Now it has been expanded without corresponding maybe infrastructure to take care of all those students. So I believe that is why the numbers have swelled. Now, proposing a solution, offering a solution to the problem, I would think that those who have already passed their LLB and are waiting to enter the law school must be given what we call an immunity. Immunity in the sense that they could be grouped and then given maybe depending upon how the General Legal Counsel are going to do it. I think they can put a system in place where the students can be, grouped and then they are given the chance to do the courses at the law school. Now we have Kumasi Campus Law School. I think UPSA is also doing the same. So if they are given immunity and all of them are offered the opportunity to go to the law school, because invariably everybody who has entered the law faculty to do LLB who wants to become a lawyer in the long run. And I do not think it would be fair for us to impede the progress of the students who want to come to the law school. So the system must be looked at again holistically. The General Legal Counsel, together with maybe the director of the School of Law, they need to sit down and fashion out. And of course, there must be, also a debate. The academia must also be involved because they also have a role to play. Somebody has suggested that the courses being run at the law school must be taken there to the law faculties. That is another way of maybe solving the problem. But the question also arises that the courses taught at the law faculties, they give the students the basic foundation of the law, theoretical. What is taught at the law school are professional courses. So most of the courses there are practical. Therefore, if the law faculties have the capacity to run those courses with the oversight responsibility of the General Legal Counsel, ensuring that, because here too we are talking about quality assurance must be applied. So the General Legal Counsel must also get involved in some of these matters and find a solution to the problem. Thank you.
Thank you, Chair. My second question. Judges are seen not to have a social life because of the kind of work you do, pressure on you to read cases and run around. How do you balance your social life with your career? Thank you.
Thank you. The life of a judge is something which, unless you have come into our fold, you will, because the steps that you take, wherever you go, and the things that you do, you are in the public eye. So when we are also talking about trust in the system, you, the judge, you must behave yourself such that people will have confidence in the courts that they are coming for justice. It's not only that the justice must be served, but they must be seen that justice is being done. So, for example, if I'm a judge and I move my car and go around, taking on board all manner of people as my friends, it gives room for suspicion and the rest of it. So sometimes you have to isolate yourself. Me, for example, I pick and choose my friends. And if I haven't traveled out of town, Sunday, I will make sure that I go to church. So my work and church. I believe yesterday, the last nominee said something which we were all amazed that because of his work, his marriage has to suffer. That is a kind of reality. So, and the point is that even if you see a friend, a lawyer, you can't even go and shake hands with him because people will say that, he is the friend to the lawyer. So that is the situation we find ourselves. But you see, that is the job we have sworn to do. So we will manage it. Thank you.
Thank you, Mr. Chair. No further questions. Congratulations once again. All the best.
Thank you very much. Then I'll give the floor to Honorable Yaoboma.
Thank you very much. Congratulations, my Lord.
Thank you.
Chairman, full disclosure, my Lord has been a very good friend of mine for many years. And I'm happy to see you go up as a Justice of the Supreme Court. Even if you are going to spend a year there, we know what you are going to send up there. And I wish you well.
Thank you.
My Lord, first time I appeared before you was about 14 years ago.
Oh, that's so?
I remember Republic versus Oseje, Antonia Kuto Osei, Jambafo, also Professor Jambafo. And the former Attorney General was for Oseje. Brilliant submission of no case, which you upheld. A 90-page submission of no case, which you upheld. And Oseje got out of the woods. I've read recently some decisions of yours, the Amewu matter, the Atufosi matter, that I know you to be a very bold judge, regardless of who is before you.
Thank you.
And that is commendable.
Thank you for the observation.
That's very commendable. What gives you that weight and motivation? Because the kind of cases that I've read you handle and taking those bold decisions are very political in nature. The stakes were very high. I would have wished my colleague Balfour to have been around, since he said most of your cases are overturned on appeal at the Supreme Court. Some of these cases that you also overturned came from the High Court. So I would want to hear your views on some of them. The Amewu matter, the Oseje, Jambafo, Atufosi and Co. So those are matters that you've determined already, so you can give us an overview. Thank you.
Thank you, Chair. In the Amewu case, is it what? Amewu?
Amewu, John Peter Amewu.
John Peter Amewu. That case is still sub judice. What came before us was for an application, interlocutory, for an application for interlocutory injunction. So the case itself is pending for hearing, the appeal itself is pending for hearing. So it will be unethical for me to say something about it. Thank you. In the case of Oseje,
hello, do you still remember the facts? Talk about some rice importation from India.
From India, I do to some extent, but it's, as you rightly said, it's a long time ago. So what I would say is that in that particular case, or generally, my position has always been that as soon as I hand over my judgment, I don't think about them again. Because if you are dissatisfied with it, you have the opportunity to go up. So it will be very difficult on my part to discuss it now. Unless, so please, let's.
My Lord, I'll step it down and,
thank you.
And ask you if you still have some good friends at the bar, because when you are at the Financial Court 1, anytime a case is brought to you and the lawyers discuss.
Right, good afternoon. Thank you very much for joining me this afternoon on Good Afternoon Ghana Business Edge. And so because of the sitting in the Parliament, the vetting of the judges, nominees to the Supreme Court, we haven't been able to bring you the news bit of Good Afternoon Ghana. However, the business segment is on, Business Edge. And so you want to join us at least for the next hour and about 25 minutes. And let's go through what's happening around the world of business. And when we are done, we can quickly go back to the Parliament House to continue listening to what the judges are telling us. So you're welcome here to the show. Thank you very much for joining in. We are coming your way live from our studios here at Rich in Accra. It promises to be an exciting afternoon. What's happening in the world of business, what's happening is that Fitch has upgraded Ghana to B-. And we'll be discussing that, the dynamics of that, and what some of the minority members are claiming that it was their action which has caused the upgrade of the country to B-. We'll do the analysis of that, but not politically anyway. How is it going to impact our economy and our economic growth? We'll do the 1 cedi per levy later. The minority, despite the postponement, is still demanding